Distinguished delegates, we will start our afternoon session, and we will dovetail nicely on this morning's session where we looked at the various elements of the dispute resolution in the digital economy. One of these elements stood out, and that is the practice that has now kicked in for the last 2 years of holding online meetings, but there are also other elements. So we will first hear from institutions, arbitration institutions, how they have navigated, they have adapted to the changing conditions, and particularly to these online proceedings. But we will also hear later on issues of witness examination, and we will also look more closely then into developments in the African region and in China. And before giving the floor to our first speaker to introduce the answers or the adaptation by institutions to the new conditions, I would like to simply remind all the speakers to kindly stick to your assigned time. We did not manage to have a discussion with the working group this morning. We very much hope to be able to have a discussion in the afternoon session. And so please stick to your allocated time for your intervention, but still speak slowly. So don't rush in the presentation, because that would then create issues with interpretation. So without further ado, I'm giving the floor now to Kevin Nash, who's the Deputy Registrar of the Singapore Arbitration Center, and who will tell us what has happened in Singapore as regards digital tools, hybrid hearings, exchanges of documents, and other adaptations to the changing circumstances. Kevin, over to you.
Thank you, Madam Secretary. Good morning from Singapore. Thank you to the UNCITRAL Secretariat for this invitation. It is great to see all the distinguished delegates and observers. I will start with some good news from the perspective of an institution. Dispute resolution in the digital economy is working. While the medium has, to a certain degree, become the message and shaped our perception of dispute resolution, the fundamentals of arbitration remain the same. Arbitration is flexible, customizable, a creature of contract, and characterized by a primacy on party autonomy. It is quick and cost-effective. Parties get to choose their deciders, confidential, limited avenues of appeal, and international enforceability under the New York Convention. The challenge for arbitration as a practice and for institutions is how to remain faithful and improve upon these fundamental tenets through the use of digital tools. Let's start with how a typical digital arbitration case might proceed, viewed through the lens of the Singapore International Arbitration Center or any institution. This would include cases across a range of seats, governing laws, and potential places of enforcement. So to kick things off, the notice of arbitration would be filed by email or perhaps uploaded through an online filing system and sent electronically to the respondent, subject to any physical service requirements in the domicile of the respondent. The respondent, for its part, would also upload or send its response electronically. In the digital economy, parties may be more likely to use institutional time and cost-saving mechanisms, such as the expedited procedure, whereby an award is rendered 6 months or 9 months from the constitution of the tribunal. Naturally, all of us in this working group would be very familiar with the UNCITRAL expedited arbitration rules. An institution such as the Singapore International Arbitration Center, which could be administering under the SIC rules, the UNCITRAL rules, the UNCITRAL expedited arbitration rules, may have its secretariat working remotely, and like most every institution, will have an electronic case management system to assist with the administration of the matter. There is much more automation with these case management systems, more consistency, and less of a relatively opaque institutional curtain. At SIC, we have tried to be adaptable, and we've tried to make it more user-friendly for its users. So even the introduction of a live chat feature on our website we have found has been very helpful, particularly when you have parties from many different jurisdictions around the world. Following any potential pre-constitution applications, a tribunal will, of course, be appointed by agreement of the parties or appointed by the institution. There is no longer a need for arbitrators to be in the region, and the only limitation really is the tyranny of time zones, taking into account the location of the arbitrators, counsel, party representatives, and witnesses. Relevantly, tribunal expenses are minimal or nil. One of the practices that we have at SIC, which I think sounds across the other institutions, on small value cases, we used to approach arbitrators on the basis that they may be willing to waive any travel expenses. This does not arise for consideration anymore, so we can appoint the best arbitrators in the world wherever they are in the world. Following that, you would have the CMC that would almost always be held virtually for the sake of efficiency, even if there are no physical impediments in the relative venue. Pleadings or memorials would be exchanged, again, electronically. The same would apply to document production and witness statements. Relevantly, for many of us, there would be no A4 documents. Subject to the language of the institutional rules and any mandatory law, the parties may agree on a virtual hearing protocol whereby the entire hearing will be conducted through virtual means. If it's an SIC arbitration, the tribunal will then submit its draft award for scrutiny. SIC will review and approve the award. And as a matter of practice, which is important for institutions, we would first transmit an electronic copy with wet ink originals to follow. So just quickly dialing down into a bit more detail on some of these good things and the challenges that remain is the cases continue to be heard at pace throughout this pandemic at SIC and all of the institutions. This can take a variety of forms. The experience in Singapore is that we've had fully virtual hearings, hybrid hearings, and in-person hearings. It could be that the way forward is hybrid hearings, where you may have some arbitrators participating virtually, some counsel participating virtually, and some in person. As Ms. Rooney stated, moving to the second point, is that arbitration clauses are evolving. Parties are increasingly looking at tiered dispute resolution clauses where there may be a precondition to arbitration. So this could be mediation arbitration, leveraging off the Singapore Convention, or arbitration mediation arbitration, which SIC has in conjunction with the Singapore International Mediation Center. Arbitration has also become faster and more cost-effective, and this is one of those basic principles. This is why we choose arbitration. As the distinguished delegate from the United States rightly pointed out, the diaries of busy counsel and arbitrators are significantly less complicated, and there has been an overall reduction in hearing time, even if it is spread across more hearing days. We are also seeing page limits and streamlined schedules of submissions, and green benefits sit right alongside this speed and cost effectiveness. Institutions are also increasingly working together. We have seen lots of scholarship put out by the organizations, and at the dawn of the pandemic, SIC and 11 other institutions released a joint statement setting out our commitment to work together. This should provide lots of avenues for collaboration. In terms of the challenges, our distinguished colleagues have already covered some of those thorny issues, such as access, inequality of arms and technology, due process, equality and fairness, cybersecurity, protection of personal data. I will look at some of the issues which come to the forefront in institutional arbitrations. So we discussed transmissions of awards and wet ink signatures. It is not always as simple to look at the domicile of the parties to the arbitration. The place of enforcement may well be different. The choice of an in-person hearing or a virtual hearing can become somewhat complicated when the institutional rules are silent on whether or not the tribunal has the discretion to determine the format for the tribunal. Under the SIC rules, tribunals have broad powers to determine the form of the hearing, and in our Schedule 1, teleconferences and video conferences are expressly contemplated. The flood of information problem, as cited by the distinguished delegate and rapporteur from Japan, may create potential inequality through information overload. Certainly in SIC arbitrations, we are starting to see some very complex, hotly debated virtual hearing protocols, and in an effort to mitigate this effect, SIC released a guide to taking your arbitration remote, which is to try to provide a practical checklist that is accessible for parties from all jurisdictions prior to embarking on a virtual hearing. And then I suppose the actual conduct of the hearings. When we started through COVID-19, the prevailing wisdom is that the can was going to be kicked down the road and virtual hearings would only be suitable for less complex, small value cases. Counsel were saying that they needed to see the whites of the witness's eyes and feel the room. That certainly may be the case for certain high value cases where witness credibility is paramount. But what we're seeing through leading virtual hearing providers, such as Maxwell Chambers, that now virtual hearings, there can be real-time transcription, an evidence presentation operator, third-party case management platform, or simultaneous or consecutive interpretation. We are becoming more and more sophisticated, and now the most typical case is eminently suitable for virtual hearings. So looking ahead, and to paraphrase from you, Madam Secretary, for institutions and for this working group, we should embrace technology and remember that our task is to resolve disputes. We need to stay nimble and make sure to use technology to future-proof arbitration to ensure that it remains the preferred mechanism to resolve cross-border disputes. For all these reasons, I very much look forward to this working group charting the way forward. Madam Secretary, I pass back to you. Thank you.
Thank you very much, Kevin, for this very concise but very detailed presentation of the experience of SIAC over the last 2 years, and for this very positive look forward. I'll give the floor now to Julia Molina, who is going to give us the experience of the Russian Arbitration Center on how they adapted to the new circumstances and to online procedures. Julia, you have the floor.
Thank you, Madam Secretary. Distinguished delegates, distinguished Secretary of the UNCITRAL and members of the UNCITRAL Secretariat, thank you very much for initiating this discussion within the framework of the UNCITRAL Colloquium. Today, I will focus on the institutional response of the RAC and its adaptation to the change of global trends in the DRDE, including the use of online tools to increase efficiency of arbitration. Besides, I would like also to draw attention of the distinguished representatives to several issues arising in regard to the DRDE as we see them from our institutional perspective. Since the beginning of 2020, the arbitral institutions worldwide have successfully adapted to the challenges of time and have developed a number of online tools to administer arbitral proceedings. In many cases, including our experience, the arbitral institutions moved to using online platforms, which allow parties, arbitrators, and the institutions themselves to exchange their documents online. The RAC, for example, developed its own platform, online system for arbitration, which since 2018 has been used in all the cases we administer. From the perspective of the institution, I would say that switch from traditional exchange of hard copies to the secure storage of electronic documents allows to reduce not only the time costs, but also administrative fees and expenses, which is extremely important for the countries where arbitration is not very popular traditionally due to its high cost. The pandemic and the digitalization wave have been also reflected in the proportion of remote hearings. More than 90% of hearings in the cases administered by the RAC are now conducted with the use of video conferencing services. And so far, we have received no objections of parties to using video conferencing services for hearings. In the same time, some hearings are conducted in hybrid form, where there is a party or parties or arbitrator or arbitrators who attend in person. However, this may lead to some issues I will focus on later. Using online platforms and video conferencing services, we also remember of potential risks, including cybersecurity aspects, verification of users, especially representatives, and in general, issues of due process. However, to this day, we have not faced any serious negative effects in this regard. The parties, as we see, do not raise objections and do not challenge arbitral awards on the grounds of remote hearings or, for example, online notices. However, it's always very important to raise awareness of parties and arbitrators of the new tools. The arbitral institutions all over the globe have recently developed different protocols and guidelines. The REC uses own guidelines developed in accordance with the international best practices and our practice under the arbitration rules, including guidelines on oral hearings, guidelines on conduct of arbitration, and others. In our opinion, the arbitral institutions can also use different online tools and resources more widely. For example, for publication of anonymized awards and other materials to enhance transparency, or for other procedures, for example, appointment of arbitrators by the appointing authority. With all this in mind, we assume that most of the issues arising in regard to the DRDE have been already addressed or may be addressed by the arbitration community itself and do not require legislative development. In the meantime, there is a number of issues which we believe may be raised from our institutional perspective today. First, as I mentioned before, there is no general understanding if the hybrid hearings affect the parties' right to present their case. Compared to fully remote hearings, in hybrid hearings, one of the parties may be considered as the one in more preferential position, being able to use nonverbal means of communication. The other problem with the hybrid hearings may appear when arbitrator or arbitrators are not able to attend or decide not to attend the hearing in person. It is disputable, however, whether it may lead to different level of involvement of arbitrators if one of them, for example, is connected remotely. It is also disputable whether the arbitrator may attend the hearing remotely if parties disagree. Another problem the arbitral institutions and of course parties can face is whether the online notices of the appointment of arbitrators or, for example, of the arbitral proceedings can be regarded as proper notices under the New York Convention. Now, it depends primarily on the national legislation and existing practice of national courts, which may be inconsistent. In the context of administration, we also see different practices as to whether the arbitral institutions shall store case materials in hard copies. It is a very institutional issue, which, however, may hinder transition to exchange of online documents if the national courts require the storage of hard copies. Finally, most arbitral awards are still in the paper form, which also makes it more difficult to use online tools at full capacity, and in some cases may result in additional time and monetary costs for parties. For example, if arbitrators who sign an award are located in different regions. While we see that verification of awards in electronic form may also be a challenging process, the digitalization of arbitration poses this question before the international community. Summing up my presentation, I would like to stress again that most issues may be and are efficiently resolved on ad hoc basis. Still, we believe it is very important to have consistent practice, and the deliberations of distinguished delegates can certainly contribute to identifying ways of future development of the DRDE and possible means to harmonize approaches in this area. Thank you very much.
Thank you very much, Julia, for giving us, sharing your experience and also giving us your take or your views on the topics we are currently reviewing and discussing. I'm giving the floor now to Dirk Pulkowski from the Permanent Court of Arbitration to talk a bit more about the role of appointing authorities that precisely Julia has flagged, and also maybe introduce particular issues relating to states being parties to these arbitrations. Dirk, over to you.
Madam Secretary, Mr. Chairman, distinguished delegates, conceptually, three ways in which arbitration is affected by technology may be distinguished. First, we may deploy technology to support conventional arbitral procedures, and much of the going remote we experienced in the past 2 years falls within that category. Second, there is an automation of particular steps in the dispute settlement process. E-discovery or permission by tribunals to conduct document searches on the basis of search terms rather than concepts are familiar examples. The automation of elements of the decision-making process, on the other hand, remains largely a fiction in real arbitration proceedings, at least as far as the Permanent Court of Arbitration is concerned. And third, digitalization and automation of procedural steps may result in an increasing autonomy of dispute resolution mechanisms, decoupling them more and more from the supervision of state courts. Now, bearing those conceptual distinctions in mind, let me begin by taking stock of the experience of the Permanent Court of Arbitration in the past 2 years, characterized by a marked acceleration of the use of technology. PCA has seen an increased use of electronic filings through the PCA's own cloud portal or other platforms. Remote and hybrid hearings have become a regular feature. The main challenge has been the seamless layering of the services expected in a complex hearing: court reporting, interpretation, document display, public access in a complex remote package. We also see a trend towards digital demonstrative exhibits and hearing bundles, and we've invested a lot of effort into creating lines of communication and confidential virtual breakout spaces to enable intra-team discussions. And finally, we focused on security features offered by various hearing platforms, and I'm glad to say that despite initial concerns, we have not experienced any security breach during a hearing during that period. Now, heavy reliance on technology raises questions about digital literacy, especially at an institution such as the PCA supporting proceedings worldwide. Fears of a north-south digital divide have by and large not materialized, I would say. And a key reason is that video conference platforms that run on personal devices have turned out to be game changers. They have proven to be quite effective in leveling the digital playing field. Another way for the PCA to help bridge the digital divide is to liaise with participants, to test any equipment with them, and to some extent to teach them the use of the equipment. And this, of course, extends to arbitrators, whom we have often personally walked through the features they are likely to use during hearings. Finally, participants have been hosted free of charge in PCA hearing space at the Peace Palace, but also in Argentina, Mauritius, and Singapore, to allow them to join remote hearings from these facilities. Now, what I've summarized just now applies by and large to states parties as well. While states may initially have been particularly worried about losing a tech battle, so to speak, against private parties, such concerns seem to have disappeared. On the other hand, states have come to appreciate remote and hybrid hearings for the particular ease with which officials based in their capitals can now follow the proceedings. So I'd say for now, we have bridged the digital divide quite successfully, but as more complex technology enters the arbitration world, this is obviously an aspect that requires continued attention. So to take a step back, how do we see our role as an institution, as a public institution in DRDE? And I would say as a guardian of practical fairness, we support tribunals in building confidence in technology. This has involved development of hearing protocols for remote and hybrid scenarios in close cooperation with the parties. But we've also made it a hallmark of PCA administration to support each participant based on their individual needs. And we do so in a transparent fashion, affording all parties equal access and consistent with our institutional ethical obligations of neutrality and impartiality. And finally, the PCA's goal has been to reduce costs where possible. Now, as has already been mentioned, remote hearings as such represent considerable cost savings for the parties. As an institution, we have invested in state-of-the-art hearing equipment made available to parties for free or at limited cost. The same is true for electronic filings or hearing bundles, if conventionally organized. If filings are processed through specialized commercial service providers, however, The product may well have superior functionalities, but in our experience, it will also impose considerable expense on the parties. As a final point, I'd like to reflect on another angle of our work at the PCA, that of acting as an appointing authority. Just to recall, under the UNCITRAL arbitration rules since 2010, the appointing authority is empowered to appoint and replace arbitrators, decide whether a case may be submitted to a sole arbitrator, deprive a party of its right to appoint a substitute arbitrator, authorize a truncated tribunal, decide challenges, fix the fees of arbitrators, review costs and fees, and advise in respect of deposits. Novel types of procedures, such as emergency arbitration, have sometimes added to the powers of the appointing authority. For example, the power to decide the threshold question, whether a special procedure may apply. So I think the question is, do novel threshold questions, novel threshold determinations of this sort arise in a DRDE context? And the answer is potentially yes. In the future, the appointing authority could be entrusted with policing the boundary between the analog and the digital. It could determine when digital, partially automated procedures do not meet relevant standards of fairness, and in such cases, enable review through a regular arbitral process. The appointing authority could be guided in determining such threshold issues by the same principles that underlie its current mandate under the UNCITRAL rules. And these are access to justice, the enforcement of ethical standards, and effective checks on abuse where court intervention is uncertain or impractical. So what role for UNCITRAL in that process? UNCITRAL could in due course be called upon to flesh out the principles of fairness that digital procedures must respect. UNCITRAL could also identify ways in which institutions and appointing authorities can be entrusted with enforcing these principles. Thank you for your attention.
Thank you very much, Dirk, for your very insightful presentation and also experience from the PCA, navigating the last 2 years. I would like to give the floor now to Rekha Raganchari and ask you from NIAC's experience to talk about the treatment of digital evidence, which is a point that we have been heard about but not entered into in much detail so far. So over to you, Rekha, please.
Thank you so much. And dear distinguished delegates, it's really a great honor to be with you today. At NIAC, we're thinking about the Hearing Center of the Future as a leading venue for international arbitration, and of course, as to the presentation of digitized evidence, in conjunction with our friends across the institutions, and in particular those with our home in New York, so the AAA ICDR and the ICC, CPR, and SEAC Americas, as well as JAMS. Such a future must necessarily consider how best to avoid redundancy and build efficiency while serving with tenacity as institutions, as guardians of the rule of law and practical efficiency, as delegates Alm and Polkowski shared. We must ensure equal treatment and procedural fairness in the use of electronic bundles with cloud-based storage and presentation of documentary evidence. The pandemic necessarily impacted and influenced dispute resolution, accelerating adaptation, flexibility, and use of technology. Key concerns as we look to digital evidence remain as to important sensitivities, transparency, and disclosure. First, dexterity of stakeholders. I cite here the submission of the government of Japan in their letter 25th January, the conversation of the imbalance between the parties using sophisticated technology and the arbitrators using not as advanced technology, to push on reply to the question, how do we level the playing field to ensure equality and fairness at all entry ports? As we look to dexterity, a secondary question, who is providing services? As we display evidence, is it outside vendors or is it the arbitral institutions? A classic counsel replied to both, well, it depends, where party autonomy, rules, and choice is nimble. Second, confidentiality and security of evidence. We can envision here confidentiality protocols as to sharing of evidence in advance of the hearing and the limitation on the audience that has access to such shared evidence. Confidentiality protocols as to evidence shared at hearing, the use of delays, for example, to scan and screen evidence where it is highly competitive or sensitive to ensure digitized evidence does not end up in the wrong hands, easily photographed, perhaps, and even reshared. And even the limitation of digitized evidence where there is a public viewing room, particularly in ISDS matters, to avoid the dissemination of critical, competitive, and sensitive evidence. We must consider these elements thinking critically in parallel about the augmented use of technology to ask, where does artificial intelligence play a role? We can review here the draft provisions for technology-related dispute resolution at provision 8, paragraph 3, particularly the role of artificial intelligence when not overseen by an individual as critical to the protocols that must be implemented. Last but not least, I wanted to touch upon cost. Adaptation can come at a cost, of course. Let's take a sliding scale as numbers become relevant here. The beauty of optionality for proceedings in hybrid or fully remote with technology add-ons that can run, for example, anywhere from USD 8,000 to USD 25,000. To this, we have to look at what technology is implemented, how is the evidence being presented, over how many screens with how many hot seat coordinators displaying content, underscored, of course, by what I began with, the critical concern. What is a universe of contact of these documents and by whom, physically in the space or remotely? Lots to consider here as we get into digitize, lots of protocols and guidelines and thoughtfulness to craft the next steps forward. Thanks so much.
Thanks very much, Reka. I note with interest your very concrete reference to the costs involved. I think that's an important element to be borne in mind. I will give the floor now to Yasmin Lalou to give us more insight into the ICA study on physical hearings. We have referred to it this morning, and we will listen with great interest at the findings of ICA. Over to you, Yasmin, please.
Thank you very much, Madam Secretary. Good afternoon, Madam Secretary and distinguished representative. I, on behalf of myself and my co-editors, Professor Giacomo Rojas Elgueta of the University of Roma Tre, and my law partner, James Hosking of Jeffers Lindsay and ICA, we thank you for this invitation to allow us to participate and weigh in on those discussions. I'll briefly discuss the founding principles of our project before discussing the main results. And basically what prompted the project is naturally the pandemic, because we needed to address the hot topic, whether there was a right to a physical hearing that would limit the arbitrator's discretion to order a remote hearing and allow a case to proceed to completion despite the confinement. Whether there is a right to a physical hearing, which would in turn give room to dilatory tactics. The founding principles of our survey was we had to focus on the right to a physical hearing in international arbitration, not litigation. We sought to provide a comprehensive coverage which was based on comparative law models, which had been fashioned since the 1960s. We needed to remain relevant, which required some form of expedition, and it was a fast-paced project with a call for interest in September 2020 and the publication of the national reports staggered between February and May 2021. We needed academic rigor to ensure consistency and utility as a practical tool. And finally, we needed diversity of jurisdictions and reporters. We have offered 81 reports, 41 from common law countries and 40 from civil law countries. 43% of the reporters were women. 50% of the reporters hold some academic appointment. We were able to get representatives from 15 African jurisdictions, 18 APAC jurisdictions, and 10 states with less than a 10 million inhabitants population. and 72% of the surveyed jurisdictions are model law jurisdictions. Now the results. No country has a legislation that provides for an explicit right to a physical hearing in international arbitration. It is interesting to note that the indicia that were used to support this conclusion were largely the same across jurisdictions. First, the authority recognized by many arbitration laws as vesting in the tribunal a broad discretion in organizing the hearing, which includes deciding what format the hearing should have, physical, remote, or hybrid. In all jurisdictions, that discretion is limited by due process considerations, allowing the parties a reasonable opportunities to present their cases. Second, where the lex arbitri allows the arbitral tribunal to decide not to hold a hearing unless it considers it necessary for deciding the case, most reporters have considered that remote hearings are a fortiori compatible with the law, given that they provide a stronger opportunity for parties to present their respective cases than the mere exchange of written submissions. There's an extreme minority of countries in which there is an implied right to a physical hearing in international arbitration, such as Ecuador, Tunisia, Venezuela, although that is limited to the first procedural hearing, Vietnam, Zimbabwe, and, reflecting a minority view, Sweden. And on Sweden, I understand a participant in the first session stated that our survey references the minority understanding of the law in Sweden. This was originally true, but to address that concern, we have asked the leading Swedish arbitration practitioner, Christopher Lof, to provide an addendum to the Swedish national report, which sets out the majority view in Sweden that a right to a physical hearing does not exist. And both the original and the addendum reports are available online on the studies webpage. As such, now both views are reflected. Interestingly, in Zimbabwe, the right to a physical hearing is not inferred directly from the interpretation of the lex arbitri, which incorporates the model law, the UNCITRAL model law, but rather from its interpretation within the current Zimbabwean context. And in effect, there is not the technological infrastructure available in the country to contemplate the feasibility of remote hearings. That is what the reporters explained. Finally, there's a number of jurisdictions where the question whether parties have a right to a physical rehearing remains unsettled, including in China, Bahrain, Denmark, Germany, and Norway. Of particular relevance to today's audience is that what these jurisdictions have in common is that their arbitration laws are all based on the UNCITRAL model law. This is unsurprising, given that the provision of the model law that regulates hearings has given right to controversy in many jurisdictions. And I'm talking here in particular about Article 24.1, which provides that subject to any contrary agreement by the parties, the arbitral tribunal shall decide whether to hold oral hearings for the presentation of evidence or for oral argument, or whether the proceedings shall be conducted on the basis of documents and other materials. However, unless the parties have agreed that no hearing shall be held, the arbitral tribunal shall hold such hearings at an appropriate stage of the proceedings, if so requested by the party. And in particular, this provision has prompted a debate on whether the party's right to request an oral hearing translate into the right to request a physical hearing. And the strongest argument weighing in favor of inferring such a right to a physical hearing is picked from the rules of civil procedures, where oral can be understood as physical or in person. And some scholars view rules of civil procedure should operate as a gap filler when arbitration law is ambiguous or silent. But as we know, the view that procedural law, civil procedural law should weigh into arbitration law is losing ground across jurisdictions. The widespread uncertainty created by the wording of Article 24.1 of model law is confirmed by the fact that in two cases, slight differences in the text of that provision in the lex arbitri from the original text of the model law were interpreted as evidence supporting exclusion of the right to a physical hearing. And as such, in Hungary, a recent reform removed the qualifier oral from the text of the Arbitration Act. And in Thailand, Section 30, paragraph 2 of the Arbitration Act uses the expression has the power instead of shall, indicating the tribunal is not obliged to comply with the party's request to hold a physical hearing at all. So on today's question as to whether the current developments call for a new harmonized legal standard, there may be room for clarification in the wording of Article 24. Although the question is, do we want or need a universal exclusion of the right to a physical hearing, irrespective of the local realities or the parties' specific situations? The case law so far indicates that this may not be necessary. And we should bear in mind the example of Zimbabwe, where the modernization of infrastructure is the most critical to consider the viability of remote hearing. And do we want to push such agenda outside the pandemic context? Maybe. But this may be best left to the parties' preferences at the start of arbitration or later to have a physical or remote hearing or hybrid hearing, as the survey has shown that the courts will generally uphold the parties' agreement. The past 2 years have demonstrated that even with the best technology and most sophisticated and enduring counsel, remote hearings have reached some excesses trying to accommodate extreme time differences, with counsel and witnesses appearing at unduly early or late times, as Kevin Nash just described it earlier today, the tyranny of time zones. If we decide to clarify that a hearing should be interpreted to mean a remote hearing, then it should be also clear that the same standards of due process remain applicable and are not presumed to have been met by any permissive language in favor of a remote hearing. And indeed, looking at the survey responses in almost all jurisdictions, the question of setting aside or refusing enforcement of an award will ultimately depend as to whether there has been some kind of due process violation, effective due process violation by the conduct of the remote hearing. Thank you very much for your attention, Madam Secretary.
Thank you very much, Yasmin, for your interesting presentation, both of the survey conducted under this ECAP project and also your views about future work on this issue of remote hearings, or right to a physical hearing, I should say. And you were mentioning the tyranny of time zones, and that brings us exactly into where we are forcing our next speakers, because we are turning now to Sok-Chun Yun, who is joining us from Seoul, so it's very, very late, or maybe very, very early, I don't know. And he will talk to us about protocols on online hearing, but not only the Seoul protocol that we all know now about, but also other practices in the region. So over to you, Sok-Chun, please.
Thank you, Madam Secretary, distinguished delegates and participants. It is a great pleasure to speak at today's session on the topic virtual hearing. I'm a partner at Peer & Kim, a global boutique specializing in international arbitration and cross-border disputes, and will share my experience as a practicing lawyer. Next slide, please. As most of you are well aware, one of the grounds under both the UNCITRAL model law and the New York Convention, based on which an arbitral award may be set aside or refused recognition and or enforcement, is public policy. And this public policy ground includes procedural public policy. Although it may vary from country to country, typical examples of violation, I would say, of procedural public policy will include occasions where the procedural fairness is not preserved, a party's right to be heard was not upheld, or a party's right to present its case is not protected. In this connection, the discussion surrounding the virtual hearing started by asking whether it is allowed for the arbitral tribunal to conduct a virtual hearing over one party's objection. Next slide, please. As mentioned in the preceding presentation, and my understanding of the result of this state is that in majority of cases, there is no mandatory requirement for an in-person hearing. Based on the foregoing, now I would like to leave the issue of whether virtual hearings are allowed behind and focus more on how the virtual hearings are structured in real world, keeping in mind that they should not be deemed as in conflict with the public policy. Usually, a hearing refers to a hearing on the merits or on evidentiary hearing and is composed mainly of opening statements, cross-examinations of factual witnesses and or experts, and closing statements. More complex issues arise out of cross-examinations, for example, prevention of witness coaching, but as mentioned at the outset, I will limit my presentation on general aspects of the virtual hearing and expect my esteemed colleague, Ms. Yoshimi Ohara, will cover the virtual cross-examinations. Next slide, please. On this slide and the following slide, I listed up some elements that I believe worth considering when drafting a protocol for a virtual hearing. I reviewed several procedural orders and agreed protocols for the hearing that were used in the arbitration cases in which my firm was involved, but in no way these elements are meant to be exhaustive. The first point is the deadline. If the virtual hearing becomes default in the future or decided in the procedural order, there will be no need to set any such deadline. But as it is now, if the tribunal and the parties prefer an in-person hearing and conceive a virtual hearing as a contingency option, then there should be a deadline for a party to apply for and the tribunal to decide to hold a virtual hearing so that the parties can prepare in advance in terms of logistics. The sole protocol requires a 72-hour advance notice, but it appears to be on the presumption that a part of the hearing will be conducted virtually. So if a full scale virtual hearing is required, that would require more time. The second point is the time difference. As Mr. Costello rightfully pointed out, it'll be much easier for the tribunal and the parties, particularly the counsel, to agree on a hearing schedule if they can exclude traveling time from their calculation, and this is helpful for expeditious resolution of disputes. Having said that, due to the participants coming from all different time zones, there may be occasions where the hearing can last only a few hours a day. So the hearing only be as long as, for example, five hours a day at maximum, compared to 7 to 8 hours in an in-person setting. And if there is another participants joining from other time zone, it becomes almost nightmare. If it is a big complex matter and the hearing were to span a few weeks, then the virtual equivalent of it will be as long as more than a month. Combined with the Zoom fatigue, which necessitate more frequent coffee breaks, this may get worse. So this aspect of virtual hearing should also be considered. The third point is limitation on participants. In an in-person setting, the tribunal and the parties can see who are attending the hearing based on the list of attendees as well as their site. But in a virtual setting, they have to rely only on the list submitted by each party. Considering it became normal to request the non-speaking participants to turn off their cameras and microphones during the oral pleading phase, there is no way for the tribunal to confirm if the witnesses are being sequestered or if there are any other person in the hearing room who are not on the list of attendees or joining from a laptop under someone else's name, as opposed to cross-examinations of factual witnesses and experts, where prevention of coaching is a critical issue. One may think it is not a big deal for the oral pleading phases, except for the issue of sequestration, but there still remains the issue of confidentiality. Next slide, please. The fourth point is virtual breakout rooms. In physical setting, the arbitral tribunal and each party will be allocated their breakout rooms to use during coffee breaks and lunch hours. Also, the tribunal members can whisper to deliberate on an objection raised during a cross-examination. To duplicate this function online, the host or the service provider should set up breakout rooms separated from the main hearing room, and limit access so that no unauthorized participant could join the room. The fifth point is recording. In the past, whereas the transcription was customary, video recording was not, probably because it would not justify the relevant costs over its use. However, thanks to the development of online platforms, recording of the hearing is now available at almost no cost except for any applicable licensing fees, and is widely used. Under the circumstances, one may ask if the court reporting service is still necessary. But considering the function of the real-time transcriptions, which is particularly helpful for interpreters during cross-examinations, it will not be an easy question to answer, at least until the AI dictation becomes near perfect. The sixth point is display of exhibits. This was used also in the pre-COVID era, but had not been widely adopted due to its cost, as it would require additional big screens only for it. But again, it became much easier and cheaper to show factual and or demonstrative exhibits on online platforms, as we do now. And in virtual hearings that I was personally involved, there was no occasion where no party displayed the exhibits on screen. To allow equal access for both parties to this function, there should be a common place to store files online, or the parties will have to share the same service provider. In the interest of time, I will skip the last point and will directly go to the next slide. So this is an excerpt from the previously mentioned SOL protocol on video conferencing in international arbitration, which deals with the technical aspects of the virtual hearing. I think there are two working forces against each other. One is the requirement that the technology should allow the parties to present their cases vividly as in an in-person setting, and the tribunal to read the parties as closely. And another is the concern that due to the technology divide, some parties may feel burdened to agree to a virtual hearing, which requires a high technological threshold. But as previously mentioned in the morning session, considering the costs to travel to and stay at a remote place during the hearing is almost in all cases no less than renting a relatively nearby facility with the necessary equipment, I don't believe the concern is serious enough in this context, in this regard. Next slide, please. So this concludes my presentation today. Thank you for listening.
Thank you very much, Seok-Chun, and thank you for staying up so late to share with us your experience as a counsel and using these various technologies in an online hearing context. And I'm giving the floor, as you had announced, now to Yoshimi Ohara, who is also staying with us very late. She's a partner at Nagashima Ono and Tsunematsu in Japan, and she will talk to us about witness examination and cross-examination in this online context. Yoshimi, you have the floor. We're being swatted by technology again. We cannot find in our cyberspace Yoshimi Ohara, so I'm going to ask kindly Ijeoma Ononogbu from Nigeria to introduce for us the developments in the African region as regards use of technology in dispute resolution. Ijeoma, are you online, and can we switch?
Yes.
Yes. Thank you so much for jumping in. We really appreciate it. Over to you.
Thank you, Madam Secretary, and thank you for inviting me to speak on this topical issue. To my distinguished delegates, it's a pleasure to be with you on this day, on this session. Africa is a continent of 54 countries. As you can imagine, there are divergent laws. We have the common law and you have the civil law. With regards to dispute resolution, which has always been there for years, dispute resolution has had its mark. However, alternative dispute resolution mechanisms were introduced to speed up the delivery of justice on the continent. In 2022, a faster means was used to obviously get through all the cases, given the influx of matters which had to be resolved. And the good thing about this online dispute resolution is the ability to adapt to innovations and changes, as opposed to the rigid traditional court litigation systems. Africa is working on maximizing this technology. Africa lost out on the first, second, and third revolution. Africa is keen to maximize its fourth revolution, which is the technological revolution. According to a recent McKinsey report on digital growth in Africa, the continent has seen the world's fastest rate of new broadband connections. Fastest rate of new broadband connections. The big question is Africa ready for the digital age? And the answer is yes. The next slide, please. For you to move on with the digital age, you need tech, you need internet. We can see from the graph here, Africa is doing comparatively well compared to the rest of the world. Obviously, the rest of the world is far ahead of the continent. Africa is a continent, as I said earlier, a continent of 54 countries, which means obviously Africa is doing comparatively well with regards to how the rest of the world is doing. The next slide, please. The internet usage on the continent is quite significant because it shows Southern Africa as the biggest user of internet, which is 62%. It goes on to show Northern Africa as using 56%, Western Africa as using 42%, and Eastern Africa 24%. This graph shows you the percentage of usage of internet because the internet propels the technology itself. Next slide, please. The positives in technology for Africa are quite immense. Comparatively, Africa is trending through its technological platform globally. The World Bank projects that the global growth in the world globally, there are 20 out of the fastest growing economies in the world. 11 will be from the African continent, which includes Kenya, Zimbabwe, Kenya, Mauritius, South Africa, Nigeria, Egypt, Kenya too. Remarkable advancement in dispute resolution has been seen with the opening up of the Africa market through the AfCFTA, which has actually helped link the continent together. And what was initially closed is now open because of technology. Entrepreneurs on the continent are using technology in ways that we've never seen before, just to conform to the continent terrain with amazing results. Next slide, please. In the African country with dispute resolution developmental growth are quite significant because the countries have all recognized the importance of technology as a driver of development and access to justice. Africa as a continent has had some challenges with regards to justice, which means that in some instances we've had cases that actually lasted for years. An example could be the land cases, where you've had matters last for 10 years, 15 years. However, with the influx of, or with the introduction of ADR, alternative dispute resolution, this actually helps it. Now, with the influx of technology, with the virtual court, it's speeding up these things, speeding up the resolution of these disputes. The good example is in Egypt, which had an e-filing of civil lawsuits, which was propelled by the pandemic. Prior to the pandemic, the e-filing of lawsuits weren't really there, but with the pandemic, it's actually escalated. So you have a lot of cases which are filed through electronic means. In Egypt, this also goes on to Kenya. Kenya as well is notably one of the fast drivers of the digital economy on the continent. Kenya currently has digital courts which are able to resolve disputes speedily within a short period, which is really important and quite significant. And one must actually commend the Kenyan people and the government for what it's doing. also followed by Tanzania, which is also into e-filing of civil cases. So back in the time, we were required to file these cases physically and individually, but right now it can all be done digitally through the electronic means, which is quite insignificant and quite compelling, given the terrain on the continent. Another important country to also note is Tunisia. Tunisia has a national artificial intelligence strategy, which deals with both the dispute resolution mechanism as well as healthcare, the medical side of things. Tanzania is out to ensure, so Tunisia is out to ensure that the country is in alignment with other countries with regards to artificial intelligence, and that other countries on the continent also imbibe a strategy of national AI means of resolving things, both healthcare or dispute resolution. And the country also to take note of is Mauritius. Mauritius has a digital signature, which is quite important because lots of Africans have reservations about implementing digital signature, but Mauritius has been on the forefront of implementing digital signature to its contracts, to its disputes when they are resolved, which is quite significant and important. And that one is Nigeria, which also was able to maximize the pandemic with virtual courts as well as e-filing of civil lawsuits. All this stemmed from the influx of technology during the pandemic. The last is South Africa. South Africa has come up with a very unique style, which is the smart drafting platform, which makes use of blockchain, which I'll talk about much later in this presentation. So South Africa has come up with a very significant and important means of dealing with dispute resolution. In as much as it has the virtual court, it also has the digital way of drafting contracts, which is under the blockchain. The next slide, please. The great development of dispute resolution on the continent is quite significant because inherently the African continent as a whole resolves the disputes through mediation, which is where you have the elders resolve the dispute. So therefore, mediation has always been the fabric of the African people. They've always resolved their dispute through mediation. However, with arbitration, disputes are resolved when it concerns commercial disputes. So when it comes to commercial disputes, arbitration is applied. When it comes to civil matters, mediation is applied, which has always been there right from the onset of the African institution, African community, African living. Technology used in dispute resolution has also welcomed the use because of the efficiency, the effectiveness on the continent. The continent is quite big, massive, but with dispute resolution and now with the welcoming of technology, we're able to cross borders. So disputes can be resolved across jurisdictions easily, faster, and more efficiently. Next slide, please. Adoption of digitalized solutions. Africa is adopting digitized solutions fast out of necessity and maximizing the pandemic as an opportunity to get to the next level. Africa is also keen on leapfrogging like she did with M-Pesa in Kenya and East Africa, in Kenya and Uganda. This is a mobile technology which has been used for monetary transfers, which was very efficient. The countries of India and Brazil learned from the East Africa and imbibed this method of money transfer, which is called M-Pesa, which was because East Africa was able to leapfrog. She didn't have to go through the hurdles the Western world went through. Rather, she came up with her own peculiarities that would match that part of the world, which is East Africa. Consequently, Africa is capitalizing on the leapfrogging opportunity, like I earlier said. The technologies on the continent show the scale and speed at which technology is transforming traditional socio-economic sectors. Next slide, please. With regard to digitalized ways of resolving disputes, artificial intelligence is playing a very phenomenal role. The African Union created the African Group on Artificial Intelligence, which has developed a unified AI strategy across the continent. Like I earlier said, Tunisia has its own AI strategy, which is peculiar to Tunisia, but the African Union, which is the bigger body for the African continent, has come up with a strategy which cuts across, which is going to apply to all countries on the continent the 54 countries on the continent. So therefore, at the end of the day, Africa intends to have one strategy that will apply across board within the continent. The next matter to explore with regards to digitalized solution is the legal technology. In the West, the digital technologies, the legal technologies are quite advanced. Africa is making a catch-up in the sense that she's supporting e-disclosures, electronic filing, like I earlier stated. Africa is keen to support technology and making sure this matters, most matters when it comes to dispute resolution, are resolved speedily. And you can only get this through technology. So they're trying to create an access to law as well as access to justice. With electronic e-disclosure being introduced into the continent, which is still at its fundamental stage, the intention is to make sure it's able to galvanize the continent together so that documents can be reviewed easily and speedily. Are there challenges? Yeah, there are challenges, which I'll talk about at some point now. Blockchain is also a very important aspect which helps with digital payment infrastructure, digital tracing, and trade facilitation and solution. Blockchain is really important because of the importance of digital payment, the importance of making payment when you seek for solutions. Are there challenges to these digitalized solutions? Yeah, there are challenges. One of the biggest challenges, infrastructure. That's one of the biggest challenges on the continent. However, given the number of youths on the continent is keen to maximize the pandemic as well as maximize its numbers. Africa has got the numbers on its side. We have over 40 million young people who are hungry to maximize the digital revolution going on globally, which includes both the healthcare sector, the dispute resolution sector, just so many of the aspects of human existence. And these youngsters are keen to make sure that Africa benefits from the fourth revolution because she missed out on the first revolution, second and the third revolution. The next slide, please. Reasons for online platforms and dispute resolution. Consumers have resorted to expressing their grievances through social and print media. Therefore, it's important that the platform to resolve the dispute. Thankfully, some countries like Nigeria, Ghana, Kenya, Tanzania have all set up, Egypt inclusive, have all set up digital online court, virtual court to resolve the dispute speedily. So it doesn't linger on, so it doesn't have to go to the physical courts. There are no legislations available for the regulation of online generated disputes online. However, some countries are currently in discussion on curbing cyber generated complaints and disputes. Kayemu Limited set up buyer protection mechanisms to resolve online complaints and disputes from consumers who use their platform, which is also a very good way of resolving disputes. That's an online dispute resolution platform. Next slide, please. Merits of online platforms. Online platform on the continent will help the continent in a great deal, although it's at the infancy stage on the continent and showing progress. But however, it's important that Africans who are hungry for technology maximize, which they're actually doing at the moment, which is quite impressive. Technology today has become an important factor in economic growth and development of countries, whether it's the Asian world or the Western world or Africa, anywhere. Technology is important and it's making life a lot easier and simpler. Digital platforms for the resolution of disputes will be successful on the continent with an improved access to justice, opportunities for handling small claims, and the resolution of e-commerce disputes. Next slide, please. The future of online dispute resolution on the African continent. Is there a future on the continent? There's a massive future of online dispute resolution on the continent. The timeless motto of dispute resolution is prevention is better than cure. Africa as a continent is keen to prevent disputes as well as resolve the disputes in a timely manner. Africa, with its huge market and resourcefulness, is predictably the next big thing in the use of technology in dispute resolution. The possibility of the EU ADR directive is most likely to filter into Africa with a tailoring of legislation to fit the African continent. It's important because Africa is unable to use exactly what the EU ADR directive stipulates because Africa's setup is quite different from the EU setup. Therefore, Africans are keen to have its own way of resolving disputes that suits the terrain. Then lastly, innovative ideas such as the resolution of disputes online has its place with huge potential on the continent, given the number of small claim cases seen annually on the continent. Once again, I say, is Africa ready for the digital era? Yes, Africa is ready. Is Africa equipped? No, she's not necessarily equipped as much as possible. Has she got a future? Yes, she's got a bright future with regards to the digital world. And online dispute resolution going to strive on the continent? Yes, it's going to strive massively on the continent. Thank you.
Thank you very much, Ijeoma, for your for pleading so nicely and convincingly the cause of technology in Africa and the development of the African dispute resolution market. Thanks very much for this information. And I will now give the floor to our last speaker, because we are still missing Yoshimi Ohara. I'll give the floor to Ming-Chao Fan, who is going to discuss with us, and it's also a preview for the session of tomorrow, developments in China, and particularly the application of artificial intelligence to dispute resolution. Ming-Chao, you have the floor, and you will be speaking to us in Chinese. Thank you very much.
Well, thank you very much, Madam Secretary, colleagues of the UNCITRAL, distinguished representatives, ladies and gentlemen, good morning, good afternoon, and good evening. To talk about the application of AI technology in dispute resolution, I would like to touch upon briefly where we come from, where we are, and finally where we are going within the next 7 minutes. Thank you very much, Madam Secretary, for mentioning that I'm going to speak in Mandarin. However, for the convenience of most of the participants, I would like to continue speaking in English, but my slides will be in Chinese for the accuracy of some of the terminologies, if I may. First slide, please. Thank you very much. Would my colleague help me to turn to the first slide, please? Perhaps second, if next one.
Cha, why don't you proceed while we try to locate the slide, which is also lost in the cyberspace.
Thank you very much, Anna. I continue with the presentation. During the past decades, we have witnessed dramatic changes. Thank you very much. And this is the slide. We have witnessed dramatic changes in arbitration, mostly because of the increasing demands for arbitration services in both local and international communities, based on the common understanding that arbitration is an effective and efficient alternative mechanism to litigation. Taking Shanghai Arbitration Commission as an example, the caseload of Shanghai Arbitration Commission increased from 2,512 in 2017 to 6,017 in 2021, almost 3 times as many as in 2017. Ironically, however, the more arbitration is used, the more legitimate questions it faces. On the one hand, the more demands for arbitration, the less efficient it becomes because of the increase in the number of capable arbitrators, and arbitral institutions can hardly match the increase of the demands for arbitration services. On the other hand, the more arbitration cases happen, the more similarities are seen among cases. And unfortunately, the more incoherence of arbitral awards happens in practice. Because one, the quality of arbitrators and arbitration services vary from one case to another. And two, arbitrators think differently in similar cases, even if they are all top class ones. This seems similar to the problems that litigation faces. a much greater number of cases to be effectively and efficiently dealt with, and at the meantime, the consistency of judgments to be ensured. Next slide, please. So looking at the application of AI technology in the judiciary in China, which is called smart court, the whole life cycle of litigation has been divided into 3 phases, i.e. pre-court proceeding phase, court proceeding phase, and the post-court proceeding phase. In phase 1, where disputes rise, it is convenient for a disputing party to get a smart legal opinion from a PRC Ministry of Justice run website, China Legal Services, by filing in a form to provide key facts of the dispute. The disputing party will receive an AI legal opinion based on metadata of legislation and precedents for the party to have a rough evaluation of the success rate in the potential litigation, and eventually decide, among other things, whether it would be worthwhile to initiate a litigation. Should the disputing party decide to launch a litigation in phase 2, on the one hand, the disputing party may file his case at the court's website, and the notices of acceptance of the filing and the production of evidence and etc. will be generated with 1 click. And on the other hand, the judges will be assisted by AI clerks during the hearings and by metadata system of legislation and precedents when drafting judgments. In phase 3, finally, during the stage of enforcement, blockchain technologies, as mentioned by many of my panelists, is applied to ensure the enforcement. Next slide, please. So therefore, in this example, efficiency has been improved for the parties, the judges, the enforcement by applying AI technology. I've listed some of the key features of key advantages and takeaways of the application of AI in the whole process in this slide. So next slide, please. It should be noted that AI seems to play a less important role in complicated cases where human being judges do, because complexity of the cases, such as cultural and historical backgrounds of the case, usually requires more than algorithm. However, the application of AI literally sets human being judges free from these simple but large numbered cases, and to focus on those that can only be well dealt with by human being judges, which eventually help to improve the quality of judgments of such complicated cases. Next slide, please. To further broaden the horizon of dispute resolution, it would be interesting to compare the mechanism of dispute resolution to a spectrum. On the left end of the spectrum is negotiation, which does not require the participation of a third party, while on the right end of the spectrum is litigation, which requires the participation of the most powerful third party, the judiciary. Between the left and the right, there are numerous alternative dispute resolution mechanisms, including arbitration, mediation, experts, and etc. If we take this spectrum of alternative dispute resolution mechanism as a x-axis and add the application of AI as y-axis, there is no reason why the application of AI in arbitration would not be so helpful as that in litigation, as long as intersection points of the application of AI and arbitration is carefully identified, at least theoretically. Next slide, please. However, the more AI applied, the more ethical concerns rise, namely whether AI would become a neutral fourth party in addition to human being arbitrators, or even a new neutral third party in dispute resolution to fundamentally replace human being arbitrators. It is difficult to predict, but there will be at least a 3-stage before human being arbitrators are literally replaced, i.e., number 1, where human being arbitrators only take the AI legal opinion as reference to their awards in stage 1. 2, where human being arbitrators may veto the draft award drafted by AI without reasoning in stage 2. And 3, where human being arbitrators may only veto the draft award drafted by AI with sufficient reasonings. It appears that we still have enough time to consider the pros and cons of the application of AI in dispute resolution and enter well-written legislation and treaties to address these concerns before we would be eventually replaced by AI arbitrators. Next slide, please. For your kind information, this presentation is prepared based on an article discussing the ethical issues of the application of AI to be published on the IBA Journal of Dispute Resolution International in May 2022. These ethical issues include, but are not limited to, number 1, is it ethically acceptable to use AI technologies as the sole arbitrator in cases with simple fact patterns? Number 2, what level of transparency do we need given the AI is black box reasoning? Number 3, how do we define bias? What type of bias should be avoided when we train the AI? And number 4, how to hold AI accountable? Thank you very much again for your attention. I wish this curriculum a very good success and all the participants a very fruitful discussion over the next days. Thank you very much. Back to you, Anna. Thank you.
Thank you very much, Ming Chao, for this slightly provocative presentation, which is making us wonder if someday we're going to be replaced by robots or by artificial intelligence. But I think it's a preview of some of the topics that will be discussed tomorrow, where we will be going into blockchain arbitration, which is not so much of science fiction, I understand, but we will also be looking at, yes, as I mentioned, blockchain-based dispute resolution. So thank you for all these interventions, all these presentations that we have designed with the view of bringing together, looking at what practice is doing, what has developed in various parts of the world, where there is potential for these developments, but also looking at the adaptation of the dispute resolution industry to the challenges that it has been facing in the last 2 years. So we've heard a lot about practice, we've heard a lot about practical experience, and we will have, of course, a discussion about what are the legal responses to these practical challenges and these practical developments, but and we will do that at various stages of this colloquium. But I would still like to open the floor now for some interventions. You may have doubts, views, questions for the speakers, but also maybe share some of your views about what we have heard today. And I really wanted to kick that off by suggesting that there is obviously a clear need to embrace a technology as it is being developed and as it interacts and impacts dispute resolution. But where are there needs for safeguards? Where are there needs for minimum standards? Are there challenges to the integrity of the proceedings, of the procedure of international arbitration? How does it reflect on efficiency. So all these points I would like to put on the floor for you to react to in the time that is left. And I'd like to open the floor for discussion from our online participants, but also from our participants here in the room. So over to you. Mexico, Switzerland. All right, so I'm going to give the floor to an online participant from the IGLIP, which is this Hong Kong Department of Justice-based research center to research online dispute resolution. And I will give the floor to Michael Fang. Michael, you have the floor.
Hi. Distinguished participants, particularly distinguished speakers. I'm from IGLIP on ODR. IGLIP stands for Inclusive Global Legal Innovation Platform on ODR. And so many thanks to Madam Anna, Secretary of UNCITRAL and other UNCITRAL officials spend so much time in our 2 meetings of IGLIP on ODR. My question is about the worry about the technology used in DR, dispute resolution in digital economy, DE. And this kind of worry is back to the working group for 1996, the model law on e-commerce. So when about the hand signature, so and the people worry about hand signature. Actually, the fake hand signature is more dangerous than the digital signature. For example, the oldest investment bank in UK was claimed bankruptcy because of the forged signature. So right now, we can say we can borrow the we don't have the reinvent the wheel. We can borrow some principle from the former UNCITRAL model law or convention. For example, the function equivalency. Function equivalency means electronic communication is equal or equivalent to the paper-based communication. So for right now, the documents, the secret note, and the legal issue of related to the digital dispute in digital economy, and mentioned the ICORD, and ICORD means International Council of ODR, and the National Center for Dispute Resolution. Their standards, the standards can address the worry about the dual process and accountability. For example, they talk about they quoted the UNCITRAL tech notes on OTR. So the offline and the offline supposed to have same standard. Why? Because they're offline and online context apply the function equivalent. As long as they have the same function equivalent, you have applied. Even in China, the Guangzhou Internet Court used the function equivalent principle. When the vice president of guilt translation. So we are not supposed to worry about the technical issue. So the ICORD, the National Center for Technology, have three speakers on the list of speakers. I think the standards is right now will be the standard of American Bar Association. I make it simple. The standard, they use the keywords. We are not supposed to use the complicated legal terminology or technical terminology. My last sentence make it simple. The standard I found on the ICORD and the National Center for Technology Dispute, they use the keywords. I can summarize, use the IC fast. I means ODI is very fast. I means keywords is impartial. S is security. E is efficient, effective. F is fair. A is accountability. S, once again, security. T is transparent. So this kind of standard can apply to the application of technology in digital resolution in digital economy. So thank you so much for your attention.
Thank you very much, Michael, for reminding us that there is no need to reinvent the wheel, because there are some standards that are well known to those who know the UNCITRAL work on e-commerce that relate to technological neutrality. We mentioned that this morning, to non-discrimination in the use of electronic means or electronic documents, and of course all of this based on functional equivalence. If it's the same, if it performs the same function, it can then it should not be discriminated against. So definitely these principles could, in the same by the same token, also apply to dispute resolution in the digital economy, as the standards of digital trade apply to the transactions in the digital economy. So thanks for reminding us of that. We will have to follow up with you on the acronyms you have been using in the end, because we did not capture them very well. But I think you summarized the fundamental principles that should apply whether you are online or offline. So thank you for that. I'm giving the floor now to the distinguished delegate of Switzerland, who is in the room, Michael Schneider. Michael, you have the floor.
Thank you, Madam. Thank you, Madam Secretary. I have to start with congratulations and thanks to the Secretariat for having prepared an exceptionally interesting and broad presentation. I think it gives an excellent basis for the discussion in the working group, which I understand is called upon to distill from this vast amount of information advice to the Commission of what can be done in the sector. Now, the information we have is so diverse and so challenging that the next step, I think, is that the working group addresses the possibilities of concrete action at the level of the Commission. Now, I am not quite sure whether at this stage this discussion of the working group should take place, or whether you prefer to hear more voices on what we heard today, increasing the diversity and the challenging information, or whether you would like us to start already now the discussion of the lessons that the working group will draw from this diverse and challenging information. So it's at this stage a question to you, Madam Secretary.
Thank you very much for this question. It's indeed with that in mind that we have put together this very diverse program with the view of really taking stock as much as we can, and in advance of this DRDX stock-taking project, that we really want to broaden the spectrum in order to have a clear view of what to take stock of, because that we are still reviewing and discussing this DRDE project, which Japan, the government of Japan, has proposed and which is already on the table, which is meant to take stock of the evolution of dispute resolution in the digital economy. And there are different elements that we want that we are putting on the table with a view of validating these different technological developments or these dispute resolution developments, also these challenges, and see whether we are on the right track by having identified them as potential disruptions by technology or potential, I would say, additions or improvements by technology. So that's really what we would like to focus this discussion on today, is really whether in the dispute resolution in the digital economy project and the working paper 222, we are capturing the right issues, the right challenges, and the right, whether we're taking the right approach, basically. Over to you, please.
If you permit me, then I will reserve the comments on specifically on the work of the working group and the Commission to later, and say at this stage a recommendation that the extraordinary presentations today be recorded in a publication. I think it's so diverse and so useful that I've rarely heard assembled in this form. So if that is possible, and if there's recording of all these interventions, it would be useful for the Secretariat to have the fruit of its extraordinary preparation recorded in a publication. Thank you, Madam Secretary.
Thank you very much. Yes, we will do so. We will have that available after the session. Thank you. I have now on my list Mexico. Mexico, please.
Muchas gracias.
Thank you very much. Thank you. And I'd like to say I appreciate the fact that we are having this exercise. It's a perfect storm of ideas about what is happening in the area of arbitration with regard to technology support. And to have some lines about UNCITRAL's work, get some direction on that. Of these various aspects, there's one to which I will not refer and the other one to which I will refer. What I will not refer to, at least not for now, at least initially, is the challenges and experiences that people are having in arbitration with regard to technology support. What I would like to refer to now is what might the working group consider as to a direction of activities for making a contribution to arbitration. First, of course, in terms of brainstorming, just in terms of brainstorming initially, that would be the initial idea. What I have in mind as an example is evolution that was seen in an industry where I see some parallels with what we're currently experiencing. And this relates to a comment that Mr. Tobilandaro made, which was quite astute. And he mentioned, and I completely agree with him, he said that what we cannot do is, at the arbitration level, and UNCITRAL needs to bear this in mind, what we cannot do is, with the technology that we currently have and that we're using, that we would limit ourselves to doing the same as what we did before, although more efficiently. I agree with that. And when I was mentioning a parallel example in another industry, and that is the industry and business of television. When television started, and some of us weren't even born yet, but when television started, we saw what the first programs were like. It was the same format as radio programs, except that now you could see the actors and actresses. But they had a new technology, but basically they were using that new technology to do the same as what they had been doing with the old technology, radio. And we should think about that. We should bear that in mind when we think of the next stage for arbitration. I think that the practice of arbitration, with the dynamics that are at play and the evolution that is taking place with better and more norms in place and institutions which increasingly are supporting arbitration, when we look at the evolution in the laws on the books and in the judiciaries with regard to arbitration, when we look at all that, let us not make the mistake of simply using the technology well, which of course we have to do anyway as a minimum. But let's think about the leap in terms of evolution, which should be like all evolutions. It should be prudent and not drastic. But what we've been doing for the last 2 years, which was basically to use technology in a way that was efficient compared to what we did before, now we should think about how we can use this technology, leverage it to do things differently, but also more effectively, and maybe using a paradigm that we didn't have in the past, a new paradigm. And I would conclude in that when thinking about the direction we might want to follow, I'm thinking about what Mr. Castell said. The notes for procedural organization, I think they stem from the work that's been done and that has shown what UNCITRAL can do without creating over-regulation, but whether showing different options of what could be done, how things could be done. Let's avoid over-regulation. Let's be very careful with any document that we end up crafting, as we've always been in UNCITRAL. Any document coming out of UNCITRAL, we need to be careful. How can we contribute without over-regulating and without trying to divine the future is a checklist, which is very similar to what we have in the notes. Thank you very much, Madam Secretary.
Muchísimas gracias. I have on my list now Israel.
Thank you, Secretary, and I'd also like to thank all the presentations that were made. Hopefully we can have a discussion now and also tomorrow and also on Friday. I think we also like to thank the distinguished delegate of Japan for their proposal. We understand the proposal as a proposal for continuation of stock taking of developments. At least according to our understanding, the proposal is not for a current project for the working group, but we stand to be corrected. But the idea is more for the secretariat and for UNCITRAL to follow the developments in the field, and maybe a few years down the road we can consider if something can be done in the working group, in this one or in others. In trying to assist to focus this stock-taking exercise, which at least that's how we understand the discussion, we'd like to point out, make a few observations. First, we think that the basic focus should be on equality and fairness, how we can balance the use of technology with equality and fairness for parties and the due process. We think from the various issues listed, this one is the most important. The second issue, we would want a focus on how to address flood of information in arbitration proceedings. We have recently adopted new regulations for court proceedings with limitations on submissions, on number of pages, on the way of presentation. And we think the stock-taking exercise could look at that in the context of arbitration, whether there are practices like that now in light of the different technological aspects and the easiness with which technology can make very long submissions more possible. So we need to find a way to address that as well. In addition, in Israel, we have recently developed an online small claims mechanism. So it might be a good idea to look at how states developed small claims mechanisms technology, maybe to see examples of how this can be adopted to arbitration. Finally, in regards to the proposal concerning mediation, we think the focus of the stock-taking should rather be on guidelines, because we all remember that we need to have mediation as flexible as possible. So we would much rather like to see a focus on how states, organizations develop guidelines rather than standards for mediation. So hopefully with these ideas and with others, this work can be developed to have more focus. And in a few years, we'll see that one issue has really been developed fully, then maybe we can consider it as a future topic for the working group. Thank you.
Thank you very much. I have now the United States.
Thank you, Madam Chairman, Secretary. Sorry, we don't have a chair right now. I want to thank very much the presenters for today. I think we second to the comments that were made by the distinguished delegate from Switzerland and Mexico and Israel, that they were all very diverse, and we got a good sense of the ways in which technology may have been presenting problems, but in ways that it has adapted quite significantly over the last 2 years. And I think one of the things that struck us about the conversation is how durable the UNCITRAL rules seem to be in this context, that the technology seems to be grafting well onto the contours that have been developed. And I think that's a good thing. We shouldn't feel that somehow that's a problem, or we need to be, there should be a problem that arises out of that. I think it's a testament to the work that's been done so far. And in that sense, I think stock taking is perhaps the right way to go forward on this, because we are still also at an early stage. And I was very much enamored by the distinguished delegate of Mexico's analogy to the transition from the radio to television era, in that we don't want to lock ourselves into something yet. I also thought that the developments that were mentioned about how private actors are stepping in to bridge the digital divide is an important one as well, and that may create space for guidelines. But I think at this point we think that there's a good amount of information to consider, and we will continue to listen. We look forward to tomorrow's session as well in terms of where this takes us. But certainly from a stock-taking perspective, it is a good idea for us to be monitoring these developments on an ongoing basis. Thank you.
Thank you very much. I now have CCB, and it's Angelina Perdomo.
Yeah, thank you, Secretary. I'm connected online.
We cannot hear you.
Oh, can you hear me now?
Now it's okay. Thank you.
No, thanks to you. I just have a question that would be addressed to the forum. It's an open question, and it's based on an intervention of a former speaker. So this person mentioned that they were aware of the possible implications that could derive from the articulation between arbitral institutions and the judicial authorities of the seat of the arbitration when it came to transferring the case file and considering that the differences between technological advances from one side to another. So basically the question is, what has been the experiences of other arbitral institutions or practitioners everywhere around the world pertaining this interaction and the management of entirely digital case files when they are transferred to judicial authorities. And the question is mainly because judicial systems have adapted very independently and differently to this technological transition that was somehow forced by the pandemic. So basically, it's just a question about their perception and their experiences.
Thank you very much. That sounds like a very good question to discuss the compatibility between the very digital solutions coming out of an arbitration institutions or coming from an arbitration procedure, and how this then is taken over by courts that may not have the same, may not use the same technologies, or maybe not be as advanced in the case management or the case documents to have them totally digital. So I think it's a very good question that we may put out for maybe tomorrow's experts that will be discussing these issues. So I would suggest that we park it, and we'll see if tomorrow we'll find someone who can answer that very valid question. Thank you very much. I have now China. China, Madam Zhang, it's over to you.
非常感谢。Thank you very much, Anna, Secretary of UNCITRAL, and everybody. Wish you a good afternoon or morning. I've listened carefully to all the statements. I would like to say that we fully support to continue our discussion on this DRDE issue. Like just now stated by the representative of Israel and some other experts, we should particularly pay attention to the issue of using technology and online platform to settle issues and the equity and fairness issues related to those. Maybe at this stage, it is possible to explore the formulation of guidelines and other documents to provide guidance for dispute resolution institutions and parties concerned. Thank you.
Thank you very much. Do we have someone else? I see Argentina. Argentina, please. Is it from Capital?
Sí. Muy buenas tardes, buenas noches.
Good afternoon, good evening, one and all. Well, I'd first like to start by thanking the Secretariat for organizing this colloquium. We have heard this morning and then this afternoon some very interesting presentations and interesting points of view, very enriching, and also different angles and different perspectives were offered on this topic. I'd like to make a couple of comments, general comments, on the working document 222, which was presented by the distinguished delegation of Japan. Firstly, we understand that the pandemic and necessity has meant that we've had to continue learning and moving more towards greater digitalization. Also, another aspect we'd like to mention is that we share some of the concerns reflected in the working document about the need for guaranteeing equity, equality of treatment, and procedural equality in international arbitration. And that would also include problems that arise when the use of technology gives way to inequality or unequal distribution of technology amongst the parties, or any concern with regard to equal treatment of the arguments, the balance of information, informed consent, interrogating or asking questions to witnesses online, or getting their witness online. And then we understand what Japan said, and that there possible future work that's undertaken based on the questions that revolve around the document, and especially paragraph 17. Those questions should also include different jurisdictions and different legal orders, including how to address the issue of developed countries versus developing countries. Thank you.
Muchísimas gracias a usted.
Thank you, ma'am, says the Secretary.
Do we have other speakers? Well, it looks like we have exhausted local remedies, and that we are now close to our the hour for closing our first day. I would like to thank all the presenters very much. I hope that some of them have managed to go to sleep now, because we kept them up for a very long time at ungodly hours. So thank you very much to all the presenters for today, for laying out for us the different issues in such a clear and very practical manner, which has given us food for thought, as we can see, and which will hopefully help us to look at the legal implications that all these practical developments, this technological evolution has created for us in the dispute resolution industry. So I thank you very much for this very fruitful first day. I wish you a nice evening, and we will be meeting again tomorrow morning at 11 a.m. And we will be looking into mediation, into the resolution of financial disputes, into blockchain-based dispute resolution, judicial assistance, and then we will close with an open discussion the first topic for this week, which is the dispute resolution in the digital economy project based on working paper 222. And then we will turn to online platforms for dispute resolution, which is another project to be discussed for future work in by the UNCITRAL Working Group 2. So thank you very much, and see you tomorrow, and thank you to our interpreters. Thank you, bye.